And that's what my job is. So my job during this trial is to prove and add evidence to Mike Park's side of the scales. So that at the end of this trial, when you get the jury verdict form, you're going to be able to look at it and say, Mike Park has greater weight than Sean Lee. And if the weight of Mike's evidence is greater than Sean Lee's, then you should issue a judgment for Mike. So as you listen to Mr. Bay, and I'm going to come back in just a little bit and summarize our side of the case as well, as you listen to us both and you reflect on the testimony and the evidence that you've heard in this case already, I ask you to visualize the scales of justice and the weights that is being accumulated on each side of the scales. And I ask you to consider what Mike Park has presented. And I feel confident that at the end of this case, you're going to believe that Mike Park has the greater weight of evidence and that he deserves a judgment in this case. I'll be talking to you again in just a few minutes. Thank you.
Morning, folks. We made it. We're at the end. Thank you all so much. I really, on behalf of myself, my client, we thank you all for showing up, being here, doing this, putting in your best efforts. We all saw you guys were attentive, taking notes, listening, you were engaged. That means a lot. That means a lot because it's giving these gentlemen, both of them, their fair day in court, their day in court. And that's all they can ask for. We were not there. You weren't there. I wasn't there. Mr. Collins wasn't there. None of us were there. These two men were there. And they know at least their versions of what happened. The problem and the reason why we're here today and why we're going through all of this is because they have just two totally different versions of what happened. Now, I'm not here to tell you that, Mr. Park's a bad guy, he's evil or anything like that. He just has a very different understanding, a very different belief of what happened here. Likewise, so does Mr. Lee. It's a very different belief, very different understanding of what happened here. And as a lot of you pointed out during the voir dire process, back when you were sitting in the back rows and we brought you up and we asked you about, hey, what do you think about people who go into business without written contracts? A lot of you said it's not wise. It's foolish. Bad idea. Don't do it. A lot of you said that. A lot of you had experiences like that. And this case is a perfect example of why you shouldn't do it. You're right. Everybody's right. And Mr. Lee's not saying that he thought it was a good idea. He actually said on the witness stand, he regrets it. You remember that in his testimony? He said, I made a mistake. I regret that. So we're not coming here trying to convince you that this was just some horrible, evil scheme where Mr. Park, took advantage of Mr. Lee and did it out of maliciousness. That's really not our goal. If you remember what Mr. Lee said, he saw this as a mistake. He saw this as a deal that just failed. He was moved on. He was already moved on. And he just ate the loss. He just took it as a loss. But then Mr. Park comes after him, starts sending lawyer letters, sues him. So Mr. Lee, as he told you, sued him back. Did a counter and say, hey, if you're going to sue me, I'll sue you back. 2-3 years later, here we are now in court, and both men are having to recall this verbal agreement from pre-COVID, right? Verbal agreement from pre-COVID. So here's what we all know. Everybody in this room knows this for sure. They did have a verbal agreement. They both said it was going to be 50%. Okay. And they both said it was going to be to open up this gaming room in North Carolina. Those facts are crystal clear. No dispute. Where the dispute comes in is, okay, well, who was supposed to put in money and to what degree? Was it supposed to be Mr. Lee put in all of the money and Mr. Park gets credit for being the expert and the guy who knows how to do everything and find the location, so he doesn't have to put any money in because he's going to take care of just making sure this place is up and running? So, again, the operational versus the investor. Was that the deal? Or was the deal, hey, let's go into a partnership, 50-50, I put in money, you put in money, and let's make this business work? Now, Mr. Collins made a point yesterday to say, hey, well, would it be fair if he had to pay money and run the business? Well, ladies and gentlemen, I'd submit to you, we're not talking about two men that came together and started a venture that neither man had any experience in. that, hey, it's two friends, hey, let's start this new thing, let's all kick in and except you work it and I'm just gonna sit back and get the money. That's not what this was. This was a gentleman who is a self-proclaimed expert in this industry. Self-proclaimed expert. And honestly, I don't even doubt his expertise. I think he probably is an expert in game rooms and gaming and whatever you want to call this that this is. And he probably is an expert. One thing's very clear and for sure is Mr. Lee is not. He is a complete novice to this industry, to this world. Okay. So what you have is a dynamic where one guy is an expert, knows this whole industry, knows how this all works, and one guy is not, but he's got money, he's got some money, and then they link up. Mr. Lee's version of events is he was under the impression that this was going to be a 50-50 partnership. Okay. To him, that meant Mr. Park was supposed to put money in. Of course, Mr. Park was going to run it because he knew how. And he was already operating in North Carolina. Remember, he said he had 2 other locations with a whole other partner. So he was already there, he was already operating. So it just made sense that it would go that way. But so here's where things get complicated. Now, nobody can be faulted for anything that happened regarding COVID. Of course, that was out of everybody's hands. So terrible timing. These are the only 2 guys in the world that tried to start a business in 2020 and had to, suffer because of COVID. So it happens. Okay. Here's the case. All right. So you can almost break this case into 2 parts, the pre-COVID and then the post-COVID. So the pre-COVID, we just talked about it. Mr. Park admitted, if you remember, when he's on the witness stand, he admitted that the things he is suing for, the things he is claiming, the breach of fiduciary duty and the breach of contract and all, is all post-COVID related stuff. You remember that? He said, yeah, I agree. We started out, that was fine. We started running it, everything was fine. It was the post-COVID stuff where stuff got sideways. Because if you listen to what Mr. Park says, is he gets a phone call from Mr. Lee, and Mr. Lee says, hey, I want to take over operations. I asked him, said, can you help us out? Can you give us something more? Was there maybe a follow-up email or a follow-up text message? Did you actually at this time think, hey, maybe I should get something in writing? Did you do an amendment? None of that happened. The only evidence that's been presented to you that this operational investment relationship changed is Mr. Park's words that he got a phone call from Mr. Lee. Now, you heard Mr. Collins talk about the scale and the weight and the evidence. So that is the most traditional way to describe preponderance, and it's a good way to describe it. I also like to use the analogy of a football field, all right? So if you'll indulge me, if any of you know or have seen a football field, in the middle of the field is a 50-yard line. That's the midpoint. That's the point where exactly 50 yards here, exactly 50 yards there. So what Mr. Collins's team has to do is they have to move that ball to the other side of the 50-yard line, okay? That's their job because they sued Mr. Lee. So on this issue of the phone call, how could Mr. Park have proved to you and moved that ball beyond the 50 that phone call happened? It was his phone. Where's the phone records? Where's the phone records? Hey, look, on this day, he called me. Here's the incoming call. That phone number is Sean Lee's phone number. He called me on this day. Now, this is evidence, folks, of this call. Not just the convenient narrative, not just the convenient story that I got a call and he said, I'm going to take over operations. Does that even make sense to us that a self-proclaimed expert in this industry would turn over operations to a novice when everybody agrees that that's who these 2 men are? Expert, novice. Novice calls you and says, I'm going to take over operations. That's like someone who just started practicing law calling me saying, I'm going to take over the law firm. Am I going to say, okay? Am I going to agree to that based on a phone call? It doesn't make sense. It doesn't add up. And so part of your job, ladies and gentlemen, is when things don't make sense, is you got to question that. You got to work through that. And then you got to come to the conclusion on whether or not that actually moves the evidence forward. Does the ball cross the 50? Do the scales tip? Does it make sense? And really, that's the key for you all. Look, you're all very intelligent people. And I'm not going to insult your intelligence. You sat here, you watched, you listened, you saw the evidence. I think you can understand that what's going on here is 2 different versions of reality. But to support one version of reality, you have to construct a narrative. You have to come up with this kind of assumption that this person who has no interest, he told you he had no interest in running these stores. Not only did he not have an interest, his life at the time prevented it. The idea that Mr. Lee was going to drive back and forth from Atlanta to North Carolina when his parents had just died, when his wife was ill, when his kids were transitioning from high school to college, when he himself tells you, I don't drive on the highway. Mr. Park confirmed that. Do you remember that? He said, his own lawyer asked him, so Mr. Lee came to the store, right? How'd he get there? And Mr. Park said, I drove him. I drove him in his car. So again, there's just too much going on here, ladies and gentlemen, to make us believe that Mr. Lee truly wanted to just grab the reins of this gaming location in North Carolina and take it away and say, don't worry about it, I'll run everything. And then let's talk about that, right? Because putting that aside, so again, I would submit to you, it never happened. Okay, that phone call was never made. There was no phone call. There's no evidence of a phone call. There's just testimony that supports a narrative. So to me, disregard. That flip never occurred. But let's just say, okay, let's just say for argument's sake, we have to ask these questions. Well, what about that 27-month time period that everybody agrees that apparently the store was open and there was a definitive end date because, again, the authorities came in and shut it down. Right now, I'm going to talk about the shutdown in a moment, but that shutdown happens. So they make a big deal about this 27 months. And the reason that's so important is because what they've come in here and asked y'all to do is take some imaginary number, multiply it by 27, and give it to their client. The guy who didn't put $1 in. That's what they want you to do. So we got to ask ourselves some questions about this 27-month period. He says, I was not running. He says, I was happy to step back. Park says, I had other things going on. I was relieved. Okay, fine. Well, Mr. Lee was very adamant that he didn't run it during that 27 months. And when I asked him who did, he said, I don't know. I don't know who ran it. So the problem here is that nobody has shown you who ran it for 27 months. They didn't show it to you and we didn't show it to you. We didn't show it to you because we don't know. All they did was assume that because it wasn't them, it had to be Sean Lee. That's the assumption that they have operated on for this entire case. If you remember when I was asking Mr. Park, what makes you think Mr. Lee, breached a fiduciary duty or did anything wrong or stole money or whatever, right? All that line of questioning. What was his answer? Because I didn't get it. So in his mind, the mere fact that he didn't get it, therefore equals Sean Lee did something wrong. That's his logic. I didn't get it, therefore this guy broke all these rules, broke all these laws, did all this bad stuff. That's the logic, that's the assumption, that's the narrative, and that's what they want you to believe. And guess what though? Maybe if we're out there in the regular world having dinner and someone's telling you this story over a meal, that sounds compelling. It doesn't work in the courtroom when you have to carry a burden, when you have to tip the scales, when you have to move the ball across the 50-yard line. You need proof, you need evidence. You need more than just a nice story, a nice assumption, a nice narrative. Okay, Mr. Collins started by talking about if this was a movie. Yeah, if this was a movie, we'd all be sitting here wondering who ran the store. Nobody knows. And because nobody knows, you can't punish Mr. Lee. If there was evidence, if they had presented even a photograph of that man behind a counter sometime during that 27-month period, if they brought in the witness, the landlord representative who you heard talked about so much, bring the landlord in. Mr. Landlord, did Sean Lee run the store? Yes, I saw him. I was there. I met him. I took checks from him. Okay. All right. We're good. They win. But they didn't do that. There's not a witness. There is no evidence. There's not a document. There's not a picture, a photograph, a video, a text. There's nothing. And I asked him, what evidence do you have? And he kept going back. Well, I didn't get it. I didn't get it. That's the evidence. His evidence in his mind is I didn't get it. Therefore, Sean Lee's guilty. Sean Lee did it. Sean Lee stole the money. Sean Lee breached the agreement. That's how they're operating, folks. And that's why this is a challenge. And that's why Mr. Lee's in court defending himself. Because none of us will want to be put in that position where we're getting all the blame for something we're saying we didn't do. And the other side's only evidence is you had to have done it because we don't know who else did. So again, I would tell you that their entire case is propped up on just assumptions. Now let's talk about this for a second, okay? So we talked about the 27 months. I've already told you that Mr. Lee is adamant it was not him and he doesn't know who it was. And it's frankly not our job to prove to you who it was because we didn't sue them for 27 months worth of imaginary money. They sued us for 27 months worth of imaginary money. And all they have to show you are some exhibits that look like homemade spreadsheets that Mr. Park apparently put together. Now I want to talk about Mr. Park and these spreadsheets and all these exhibits, okay? Mr. Park, again, I have no doubt that he knows the gaming industry, okay? But when he presents to you on direct, he presents as a very authoritative, a very sophisticated businessman with systems and processes and P&Ls every month. Yet he lives his life with handshake deals. When he presents on direct, he presents as he's in control. He can educate you on game machines. He can tell you the difference between this machine, that machine. He can tell you how to corner old people in the store by giving them hot dogs and keeping them there all night, right? He's an expert. But when I start pressing him on cross about all the things that he believes really happened and how he proves it, you saw a difference. He wasn't quite so sure of himself anymore. Now, stumbling. Now he's getting pressed. Now he's not sure how to answer. And when he's being forced to answer, he's not giving you anything substantive. And you saw that with your own eyes. When his lawyer's talking to him, he does great. When I'm asking him questions, he's breaking down. Compare that to Mr. Lee. Mr. Lee's same guy. Whether it's me asking him, whether it's Mr. Collins asking him, same even keel, matter of fact, this is what it is kind of guy. I would submit to you that there's something about that that's very telling. I would submit to you that as judges of credibility, which you are, you're judges of credibility, you have the power to judge a witness and determine whether you think they're telling the truth or not. You know, all day in our home lives, we tell you, hey, don't judge people. You're here to judge. You're literally here to do that. So when you look at these two men and their demeanors on the witness stand, you have the power to determine whether you think one of them is telling you what is more likely to be the truth or not. And I would submit to you that if a person is consistent in their positions, regardless of who's asking them the questions, that's more likely to be the genuine truth versus someone whose responses tend to fluctuate. That's more likely to be someone who's trying to remember a narrative, someone who's trying to remember how to make this assumption go. That's more likely what that is. But it's up to you folks, because it's like I said before, you're all extremely smart. You heard and you saw what you saw. So think back. When I asked him, what evidence do you have? What documents do you have other than the ones that have been produced? And you know what? I'm glad I said that because it reminded me of something. Huge deal was made. Huge deal was made about a woman named Cheney Madden. And the plaintiff presented this information to you as if this is somehow some sort of smoking gun. Oh yeah, we got Sean Lee now. Look at this check that was made out to him. Look at this contract, if you can call it that, that was signed. So what's funny about this is that you've heard this thing called a loan agreement. You heard it called an investment agreement. I asked Mr. Park, what is this? Is it a loan agreement? Is it an investment agreement? I'm still a little confused, honestly. What Miss Madden herself said in her deposition is that she was investing in Mike Park. Those are her exact words. I asked him, I said, did you hear that? He said, yeah, I heard that. Is that your understanding? Yeah. Well, he says, well, I brought her into the deal. I introduced, again, no dispute that Mr. Lee had never met Miss Madden, didn't know who she was. No dispute that she's Mike Park's friend. What's going on here is that if we take that 27 months of imaginary money that they're suing for and put it aside, the only money that they're trying to hang their hat on that's concrete in their mind is this money here. So they're saying, look, at a minimum, Sean Lee owes us $50,000 because we had to pay off Miss Madden on his behalf. Why on his behalf? Did Sean Lee promise to pay her back $50,000? Because if he did, that would make this a loan agreement, wouldn't it? And when you go back there and you look at this, the word loan is not on this anywhere. This is not a loan agreement. It was never even intended to be a loan agreement. Miss Madden in her deposition doesn't even call it a loan agreement. So I asked Mr. Park yesterday, and you'll recall, I said, what gives you the right? What gives you the right to come in here and ask for $50,000 from Sean Lee because you decided to pay Miss Madden $50,000? What makes that an automatic, hey, you got to reimburse me situation? What are they deriving that from? It's not on the document that they've submitted to you, and it's not this copy of a check. Nothing in that creates a legal right that Sean Lee owes this gentleman $50,000. That's the most concrete amount of money that they can present to you to show you that Mr. Park actually saw he lost something. He lost something. But the problem is he admits that what he gained was 10% of this partnership, which we all know is defunct. So he got 10% of nothing, but he got 10%. And do you remember when I asked him yesterday, I said, hey, so you paid $50,000, you got 10%. Now you want the jury to give you $50,000. I mean, I'm not good at math. I'm really not. But that feels like you're getting 10% for free. Because if you spent 50 and you get 50 back, you never spent anything, did you? But all of a sudden you're 60 and he's 40? How's that fair? More importantly, where's the legal basis for it? Because it's not in these documents. It's not in Exhibit 1 or 2, and it's certainly not in anything he said on the witness stand. So where does it come from? It's a stretch, it's a reach. It's their way of trying to anchor in something concrete because they know that 27 months is just completely fabricated. It's out of thin air. It's speculative. It's not real. It's imaginary money. But that's what they want you to do. When Mr. Collins comes back up and he's going to put up his PowerPoint and he's going to show you, well, hey, look at all our damages and look at these numbers and they all add up to almost $900,000. Where's that coming from? Again, that 27 months that we've already established, nobody has any evidence of who was running the store. They didn't prove it. We didn't prove it. Nobody knows. So because of that, they're entitled to no, it doesn't work like that, ladies and gentlemen. That's not how it works. They have to carry the burden. They have to carry the burden. They have to tip the scales. They got to move the ball across the 50. And they haven't done it. They haven't done it. And it's not for lack of trying. I told you at the outset how much I respect Mr. Collins and his firm and how much I think highly of them and how I think they've done a good job with the best they can possibly do with a case of this sort. They've done it. The problem for them is not that they've not done something correctly. The problem for them is that the facts just don't work. It just doesn't add up. The narrative, it just doesn't work for them. Because as I pointed out to you, there's no reason on earth why he should be entitled, Mr. Park should be entitled to $50,000 from Mr. Lee. There's no reason on earth. As I pointed out to you, that 27-month window that they're relying on has been unsubstantiated, and there is no evidence. There's no evidence at all that that amount of money is actually due. Because when we talk about speculative damages, we're talking about things that you're just hoping would be true. He told you that what they've done is they've taken the average of the 2 months that they have data for, and they've multiplied it by 27. How do we know those numbers wouldn't have gone down? We don't. Their assumption is it would have gone up. That's their assumption. And of course, in an ideal world, if you're them and you're suing for big money, that's what you want, right? You know, and Mr. Park, when I asked him about, you know, what he told Mr. Lee about how much money this business would make, oh, you know, 60,000, 100,000 more. I mean, it's all over the place because there's no hard data. It'd be different if they walked in here with receipts, something to show you this is what the money would have been during that time period. They can't even establish who ran the store, much less how much money it made. So for that reason, absolutely not entitled to 1 penny of damages as it relates to that claim, okay? So now when you take away the 27-month claim, you take away this $50,000 claim, what are you left with? For them, nothing. They want you to think my client somehow breached a fiduciary duty. What fiduciary duties are we talking about? When I asked Mr. Park, what is it that constitutes the breach of the fiduciary duty? He says, well, when he ran the store, he didn't give me reporting and he didn't do this and he didn't do it. We haven't even gotten to evidence of him running the store. So how can he breach a fiduciary duty on an agreement that there's zero evidence of it having occurred? Zero evidence of him having stepped into that position. So this is all going back to that phone call that I'm talking about, the one that never happened. This is all going back to that. So if they can't even start the car, they can't expect you to drive. If they can't even get it going that this actually occurred and he was in the business and actually operating it, they don't get fiduciary duty. It doesn't happen. So fiduciary duty is out. We started talking about conversion, but guess what? Conversion's out. You don't have to consider conversion anymore. That's not even one of the claims in this case anymore. It's fraud, it's a breach of contract, and it's fiduciary duty. I already told you why breach of contract's not going to work. I already told you why breach of fiduciary duty is not going to work. Let's talk about fraud. Mr. Park, incredibly, wants you to believe that Mr. Lee lied to him, that Mr. Lee induced him, that he made false statements that Mr. Park relied on. And I asked him that. If you remember, I asked him on cross, what false statements did he make? What were the false statements? And he actually said there were none. I don't know if you heard that. He actually said there were none. But then he fixed it by saying, well, again, the fact that I didn't get any money, looking back on it, it had to be a fraud. Not how it works, folks. It's not how it works. They have to put evidence in front of you that Sean Lee knowingly, willfully, intentionally said something to Mr. Park that he knew, that Sean Lee knew was false. That he knew it was false when he said it. Right? So, for example, if I tell my 11-year-old daughter I'm gonna take her for ice cream, and I know I'm not taking her for ice cream. I know I'm not. I'm just saying that to get her to do her homework. And then she does her homework and puts her shoes on and gets ready, and she's like, I'm ready to go. I'm like, sorry, we're not going for ice cream. I gave her a false statement. I knew it was false when I gave it to her. She relied on it because she did her homework, put her shoes on, got ready. And then as a result, she didn't get ice cream. That's the simplest way I know how to explain fraud. It's the simplest way. Someone's got to say something to you that they know is false. And you have to believe it. And then you got to do something about that that causes you harm. Where did that happen to Mr. Park? Where's the evidence? What statement, what document, what witness, other than him, is here to support a claim for fraud against Mr. Lee? They have to put this stuff on a scale, like Mr. Collins said. So far, their scale has not tipped at all. In fact, it's tipped the other way. Balls at the 50, guess what? They just got sacked, lost at 10. It's not happening for them. There's just no evidence to support this cleverly concocted narrative, this assumption-based story that they want you to believe is, despite whatever's in this binder, despite these invoices, and the evidence isn't there, folks, because their whole case is about this 27-month time period. That's their whole case. They want to make Sean look like a bad guy for whatever he did or didn't do before the 27 months, but they can't prove anything to you about that 27-month time period. Yet they're asking you to give them huge money for that exact same time period. So look, I'm about to wrap up. I want to show you something. This is a verdict form, okay? And I'm going to show this to you all a few different times, okay? This is a verdict form. When you are back in the back room there deliberating, you're going to get this document presented to you, okay? All right, so everybody sees it says verdict form, all right? I'm going to explain to you what this is. This is literally when you hear about cases, hey, the jury reached a verdict or there was a judgment issued. Okay, so this is how juries reach a verdict. Now, this particular verdict form, you're going to see has places where you can check. So I like to say it's kind of like voting. You're kind of voting. Which one do we want to vote for? Okay. You're going to have to do it as a group. You're going to all have to agree. So you're going to have to talk it out. You're going to have points of view. Some of you might think, hey, you know what? Ms. Park did actually make a case. All right, talk it out. Some of you might say, no, we don't think you made a case. Talk it out. Once you agree, you're all going to check a box. The way the boxes are set up are as follows. The very first thing you're going to see is a box or a space for what's called plaintiff's claims. Remember, Mr. Park is the plaintiff. He initiated the lawsuit. So we're applying that standard. Did he meet his minimum burden? Did he tip the scales? Did he move the ball across the 50? He's the plaintiff. The first thing you have to understand is, all right, did the defendant breach a contract with the plaintiff? And then you're gonna have a chance to check that either we, the jury, find in favor of the plaintiff, or we, the jury, find in favor of the defendant. The defendant is Sean Lee. Ladies and gentlemen, for this first one, you're gonna check that you found in favor of the defendant, because there is no evidence to support that that 27-month contract was breached or that it existed. You're gonna have to go through that exercise. What was the contract? What were the breaches? Just like I asked Mr. Park on cross yesterday, and he wasn't able to answer. So when you go through that process yourself, we're gonna ask you to check the box for the defendant. Likewise, the very next question, and what I'm sure Mr. Collins will explain to you, is that if for some reason you did find for the plaintiff, there's a line that you go to next that says, okay, if we found for the plaintiff, how much? So then you'll have a chance to check or select and put in a money figure, okay? I'm not gonna spend too much time explaining that. Mr. Collins will explain that, the court will explain it. I'm just telling you that when you look at the issue of whether or not a contract was breached, that's the first question you're gonna be asked to judge on. My answer, my position, my argument is no. So that means you check for the defendant. You go to the second box, or the second question, as to whether the defendant breached a fiduciary duty. We just talked about that. Obviously, no. You're gonna check no, the defendant did not breach a fiduciary duty. There was no fiduciary duty. There was no contract. There was no agreement. None of the things that they want you to believe existed. So obviously, you're gonna check no and vote for the defendant on the fiduciary duty count. As to the count of fraud against the defendant, well, I just walked you through that. You're gonna check no again, because there was no fraud committed by Sean Lee. So you're gonna check no. So now that's gotten you through question 3. Then we're gonna get to question 4. And what question 4 is whether Mr. Park is entitled to recover his attorney's fees from Sean Lee. Well, to be entitled to get his attorney's fees, he would have to prove to you that Mr. Lee, the defendant, acted in bad faith, that he did something wrong, he was stubbornly litigious, he made this into a lawsuit for no reason, that he caused Mr. Park all kinds of harm and trouble and expense because he should have just paid him. All right, so if that's what you believe, you would grant him his attorney's fees, but obviously that's not what happened here. So you're gonna check no. You're gonna check no, right? We, the jury, find in favor of the defendant. So that's gonna resolve everything they got. You're gonna check defendant's boxes all the way down. Now, here comes the question on the counterclaim. All right, I'm gonna say something to you that is probably gonna seem a little bit radical, and I really don't know if too many lawyers would say this. I would love for you to vote for us on our counterclaim. I would love for you to check the box saying that you find in favor of the defendant, that he committed fraud, and that we're entitled to punitive damages and we're entitled to attorney's fees. But I'll be honest with you, Mr. Lee didn't do this to get $300,000. He didn't do this to come in here and win a counterclaim. He defended himself, and in the process of doing that, he told the truth. And the truth is, I put this money in. But remember, he already acknowledged that he lost. He said it was a mistake. He was very honest about that. And I don't know if you caught this, but he said something that actually kind of shocked me, is he said his greed got the best of him. How could it not? He's hearing these huge numbers, right? 100,000 a month, and he admits that. How many people you know walk into a court, take an oath, and then just be honest like that and tell you, yeah, I got greedy, I screwed up, I made a mistake, shouldn't have done it. And he didn't come in here banging the table and telling you, I need my $300,000 back. It's not his position. But if you believe that Mr. Park played him, knew that Mr. Lee was a sucker and took advantage of him, then you would be well within your rights to give him back that money. But we actually can win this case 2 ways. They can only win it 1 way. The only way they win it is if you go and check boxes for the plaintiffs. We can win it if you don't check boxes for the plaintiff, you check boxes for the defendants, and you give us our counterclaim. Double win, great, awesome, right? Best case scenario. But we can also win it if you look at this whole situation and say this whole thing is just a cluster. Nobody deserves anything. Nobody wins. Everybody go home. Fine. We're okay with that. Because we didn't come in here looking for money. We came in here to defend ourselves against a false claim. So if you don't want to award us the 300,000, I'm okay. We will not be upset. Because the reality is this thing was cursed from the beginning. Both men should have done a better job. They didn't. Only one of them admits it though. Only one of them admits it. The other one's trying to pin blame and get money out. But only one admits it. We screwed up. I screwed up. I got greedy. Bad idea. Shouldn't have done it. So you know what, folks? If you don't want to give us our counterclaim, it's okay. But they should not profit off of this. They should not benefit off of this. Simple as that. So if we walk out of here with a defense verdict and a counterclaim, I will be ecstatic. But if we walk out of here with a defense verdict and no counterclaim, everybody go home, I'll still be ecstatic. Because at the end of the day, I believe that no matter what happens, you all know the truth. You're smart, you saw it, you heard it, you know what's going on here. Neither men deserve to walk out of here with that kind of money if they've done this the way they did it. It's a lesson to learn. It's a hard lesson to learn. It's an expensive lesson to learn, but here we are. And if it wasn't for you all, we wouldn't have had this opportunity. We wouldn't have been able to present this information. So I thank you all so much for your consideration and your time. We simply ask that you just do what's in your heart. Thank you.
In those civil trials, there's some kind of common ground. And that would make your job as jurors much easier. So for example, if we could agree on more things, then you can really narrow down the issues before the jury. In this case, we all agree there was a partnership. We all agree that as part of the partnership, they're going to operate this skilled game store in North Carolina. And so we get to the point where we get the skilled game store lease signed, we get the building set up, we get the renovation complete, we get the game set up, we open for business. I bet this story would have been a whole lot different except for COVID. And I think COVID is the intervening factor here because of COVID, the whole store shut down, much like the whole country shut down. And the result is that we had this period starting in March where nothing could be done. And so I would suspect that Mr. Lee and Mr. Park both got distracted and moved on to other things. But then in the summer of 2020, it became time to start reopening not only the world, but also this particular store. And so that's where the stories diverge. And they diverge significantly. At that point, there is very little common ground. You have two really distinct stories, and as a jury, y'all have to decide which story are we going to go with? Which one do we believe? And so that becomes much more difficult for you as a final arbiter of who is telling the truth. So who do you believe? Well, we're back to what we're talking about, the scales. You look at the weight of the evidence versus the evidence of Mr. Lee. And I believe that when you do so, you're going to find that Mr. Park's evidence has the greater weight. So let's talk about Mike Park. He was the operations partner. He ran the store. He chose the location. He liked that location. In fact, he found that location in the fall of 2018 and massaged and worked and tried and planned to utilize that location throughout 2019. And when he got the opportunity to bring on an investor like Mr. Lee, that was when he was finally able to pull the trigger on it. I think the evidence is clear. They needed each other. The investment was something that allowed Mr. Park to divert his capital into multiple projects, allowed Mr. Lee to invest in a business that he thought was going to generate tremendous cash flow. So Mr. Park testified that in the summer of 2020, he got a phone call from Mr. Lee, and that Mr. Lee said he wanted to take over operations. Mr. Park said, well, probably is going to mean the revenue production may go down a little bit, but I add the most value to the business when I'm setting it up, when I am putting together the systems and the games and the marketing and all these kind of systems, that he believed that the business could continue if Mr. Lee ran it. With the knowledge maybe that Mr. Lee was going to run it remotely, that he was not going to move to North Carolina. Remember, for those first few months, Mr. Park lived up there. Why did he live up there? Because he worked from 10 a.m. to midnight. So he worked every single day, 7 days a week to get that store running, to get that store off to a successful start. Now, Mr. Lee testified that he went to North Carolina in the summer of 2020, that he visited the store before it reopened. And we believe that the store reopened right after that visit. And that's also, we believe, that the phone call came from Mr. Lee to Mr. Park after that visit. That Mr. Lee went to the store, saw the store, was doing a scouting trip to see what condition it was in. And we believe that Mr. Lee made the decision at that point in time that I'm going to take over operations. And that, of course, also comes into our various claims for breach of contract fraud, because we believe that the evidence, of course, in retrospect supports it, that Mr. Lee made the judgment call, the decision when he told Mike Park, I want to take over operations of the store. What Mr. Lee really meant is that I'm going to take the store. I'm going to run it and I'm going to keep all the money. After Mr. Lee made that site visit, that's when he would have called Mr. Park. And that's when they would have agreed to flip the positions so that Mike Park would then be the silent partner and Mr. Lee would be the operations guy. Remember, I just said a minute ago that Mike Park worked hard to secure this location. That was a good location. He believed in that location. There is no way on earth that Mike Park would have just walked away. The only reason Mr. Park did walk away is because Sean Lee said, I'm going to run. I'm going to take care of it, which allowed Mr. Park to go into other directions and other businesses. And certainly, Mike would not allow some third party to run the business without him being involved or knowing about it. So there's really no in between the two stories. Story number one, Mike Park would have run the business if Sean Lee had not said, I want to do so. And story two is Sean Lee says, I never said I wanted to run the business. There really is no in between. I cannot fathom a scenario, and the evidence certainly didn't indicate a scenario, where there was someone else running the business other than Mike Park or Sean Lee. So therefore, you as the jury had this really difficult job of trying to say, okay, which one of these stories do I want to believe? But I also say, y'all got to keep in mind, if Mike Park thought that Sean Lee was not going to run the business, then I think he absolutely would not have allowed that business to reopen by someone else. He would have reopened it himself because he worked too hard to get that business, to get that location. And he believed that that location was a winner. So there's no way that Mike Park would have walked away. So as we look at the evidence, we have to make suppositions. And yes, we add weight to the scale. I think that is an element of evidence that we add to the scale. That Mike Park actions, his actions were dictated by what Sean Lee did and said. Because there is no credible reason to think Mike Park would not have been running that business if Sean Lee declined to do so. Now, Mr. Baig is an excellent attorney. I think he's done a great job. I really admire the way that he's able to do stuff without an outline. I do everything with an outline, and I really do admire the work that he does. I think he's a fantastic lawyer. So I appreciate the way that he has presented this case to you. But he said that this is a case of he said, which is really simplifying the idea that it's Mr. Park versus Mr. Lee. I submit that the evidence is far more than just these two individuals. For example, yes, we presented testimony from Mr. Park, but we also had testimony from Cheney Madden. And Ms. Madden was a witness who told a very similar story to what Mike Park told. Right? She bought into the company. She became an investor. And then when the store reopened after COVID in the summer of 2020, she knew she had to go to Sean Lee to find out what's going on with the business. Well, it's very clear she went to Mike Park. Mike Park said, I'm not running the business right now, Sean Lee is. So she called Sean Lee. She called Sean Lee. She called him at least 10 times and he answered the phone once. When he answered, she didn't get any information from him. Ms. Madden testified, and I quote, "I tried to call Sean Lee many times, but if I call maybe 10 times, he answers one time." Ms. Madden said she never got any results from the calls. Despite these calls, even when Ms. Madden got Sean Lee on the phone, Sean Lee never denied that he was operating the business. He never told Ms. Madden, "Go see Mike Park. I'm not the operations guy, Mike Park is." He never said that Mike Park was running the business or that anyone else was running the business. Instead, he ducked, he dodged, he didn't answer the phone. You know, and the reason for that is, I think, because he was running the business, he was taking all the profits, and he did not want to pay Ms. Madden her 10%. Again, this is the weight of the evidence building based on the testimony of Ms. Madden. Now, if Mr. Lee had answered the phone every time Ms. Madden called, if he had said, "Not me, I am innocent," then you know what? That his side of the scale would grow. I would say that because he was ducking and dodging the phone calls, that supports Mr. Park's claim. Why would an innocent man not proclaim his innocence? Why would an innocent man not pick up the phone and say, "Ms. Madden, you're talking to the wrong guy"? Now, during cross-examination of Mr. Park, Mr. Biggs spent a lot of time talking about the contract, and he did so just now. If you would put up exhibit 2, please. So let's look at the contract. This is the deal between Ms. Madden and Mr. Lee. Mr. Lee sold 10% of his share in the business to Ms. Madden for $50,000. So everyone agrees that that's what this is, that it is a share sale. Now, Mr. Park testified that his understanding before the contract was signed was that it was going to be a loan. And I think that is what he thought, but that's not what the parties agreed. And so when the parties met, Mr. Park wasn't there. When the parties met, Mr. Lee drafted the agreement and said, "Here's what I want to do." And Ms. Madden said, "Okay, I'm fine with that." The distinction that Mr. Bank is making is a valid one. And in a loan, you would assume the $50,000 would have to be repaid. In an investment agreement, it is an investment, and so maybe it would not have to be repaid. The difference, however, is the lease is set up with a 2 years, with a 2-year lease with a 10-year option. So Ms. Madden was thinking this was a 12-year investment. This is a 12-year investment, not a 2-year investment, and certainly not a 2-month investment. This ended up being a 2-month investment. The only money Ms. Madden received, and this was in her testimony, was from Mike Park, the distribution based on 2 months of business. Now, Mr. Lee also testified and confirmed that he received a distribution from Mr. Park. And Mr. Park also sent out financial records that sent out the payment. Yes, the first payment was small, but then this was a very small sample size, just the very beginning of the business. So I would say that Sean Lee had a duty to provide the profits and the revenue reports to Ms. Madden because of that contract that they had. And as a result of his failure to do so, he breached the contract to Ms. Madden. And when Ms. Madden sold her shares to Mr. Park, he took over that right. And when Mr. Lee did not provide any more financial reports or payments or distributions during the time that Mr. Lee ran the business, then I would say that's a breach of contract, and that Ms. Madden, and by extension Mr. Park, has the right to recover that $50,000 investment. Why? Because Mr. Lee breached the contract and failed to deliver. So we presented testimony from Ms. Madden and from Mike Park, both saying the same thing. They tried to get answers from Sean Lee about the operations of the business, but Sean Lee dodged the calls. He never explained what was going on with the money, and he never proclaimed his innocence. But, ladies and gentlemen of the jury, that's not all. We got more. There's actually a third witness that did not testify because she lives out of state, couldn't subpoena her. And this third witness is Artie Lupton. She's the landlord. Now, we showed you exhibit 3. Exhibit 3 is the lease. The evidence is undisputed that this is the actual lease agreement. And the evidence is undisputed that Sean Lee signed the lease. And that Artie Lupton signed the lease. And that this is the property for. So we go to the signature page. There's been no dispute that these two individuals signed, including Mr. Lee. So we know that the terms of this lease are the 2-year lease plus a 10-year extension. If Mr. Lee had only followed the terms of the lease, that business would be open still. So let's go to the side page, if you would. This is what made Ms. Lupton unhappy. The fact that no financial records were provided, no profits were made. Ms. Lupton complained about the same things that Mr. Park and Ms. Madden said. And that, this right here called for, this side deal called for the company to send her a profit share. Why? Because the landlord provided these services. They did building engineering, they did drawings, they did works with inspections, they helped to obtain contractors, they applied for permits. A lot of retail leases involve some kind of a sharing in the profits, in the success. To my knowledge, that is a very common practice in the retail business. So this is what Ms. Lupton expected to receive. It's what's in this side deal. And so when Mr. Lee did not follow the terms of the lease he signed, that made Ms. Lupton unhappy, which takes us to exhibit 6. So exhibit 6 is the letters, 2 letters that Ms. Lupton sent to Mr. Lee. So if we look at the first page of this letter, if you would scroll down just a little bit, Ms. Lee says, to date, neither Mr. Parks nor I have received any accounting from the business property and Mr. Lee. There you go. Thank you. For the business property. And so, since I could not get Mr. Lee to answer my phone calls, I decided to sell this property, and Mr. Lee will need to vacate immediately, as I directed him to in my letter last month. So again, this is the same complaint that Ms. Madden had and Mr. Park had. She made calls to Mr. Lee. Mr. Lee did not answer. Mr. Lee did not provide the revenue reports, nor did he make his payment. Let's go to the second page, please. And then as you see, this is the letter where Ms. Lupton said, this is official notice, the lease is being terminated. The actual termination date was August 31st of 2021. She said in her letter, August 25th, 2021, and it's because she has the property under contract. That's her reasoning. So looking at this letter, we now have 3 witnesses who all say the same thing. You see, those scales are starting to get even heavier with each witness we add saying the same thing. What are they saying? They tried to get financial reports and payments out of Mr. Lee. They tried to call Mr. Lee. Mr. Lee did not answer. Mr. Lee had tons of opportunities to proclaim his innocence, to say, talk to Mike Park. But Mr. Lee did not do so. That adds weight to the scales. These witnesses are all saying the same thing. These witnesses gave Mr. Lee a chance to show that he was an innocent man. He did not do so. And instead, what Mr. Lee did is he ducked those phone calls. What he did is he did not provide financial records. What he did is he did not send profit distributions. And then, of course, we had the testimony of Sean Lee himself. He testified that he lost faith in Mike Park. After the first 2 months, after only 2 months, he says he lost faith. Why? Because he says he did not get that $100,000 per month payment. He thought he was promising. Well, the evidence is clear that this store was never going to generate enough cash to to put $100,000 into each partner's pockets. It just wasn't possible. And there's no evidence to show that Mike Park had ever said or promised $100,000 a month. And even if he had promised $100,000 a month, 2 months is not enough time of a test period to show, especially when the business is growing at 50% per month. Remember, the first month it did 36,000 in net profit. The second month it did 50,000 in net profit. This business, we know there's a cap on where the limit was. We just don't know where that cap was. So Mr. Lee testified that he stopped investing in the business, that he decided to walk away from the business, that he was going to walk away from his $300,000 investment. Yet, this is where it gets really interesting. Yet, he continued to pay the rent after the termination. He continued to pay the rent after he says he had decided to walk away. He continued to pay the rent after he had lost faith in Mike Park. Think about that. So I asked Mr. Lee on first day, Tuesday, about did he pay rent until the end of 2022? He said yes. I took a risk and asked him the same question yesterday, mainly because I wanted you guys to hear it twice, that he had actually paid rent even after he had lost faith. He had stopped investing. He had taken all these steps. He kept paying the rent. There's only one reason he would keep paying the rent after the lease termination on a month-to-month rental basis. It's because he was still running the business. He was still getting paid. There's no other conclusion that we can reach because the lease was terminated. The lease was off. There was no obligation to keep that store open. There was no obligation for Mr. Lee to make any rent payments. Mr. Lee could have stopped at any point in time. So when did he stop? He stopped when the county said, this business is no longer welcome in our county and you must shut down. So when the county said the game room, the skilled game room has to close, and that all the skilled game rooms in that county has to close, it was at that point that Mr. Lee stopped paying the rent. Of the evidence that we presented, I would say the strongest evidence was that Mr. Lee kept paying the rent. Because of all these reasons, all this other testimony, saying he lost faith, saying that he wanted to walk away, stop investing, the fact he kept paying the rent is in conflict with all of that. And it just doesn't make sense unless he is only running, operating, and profiting from the business. Even if he was running the business and not profiting, you would think that he would have just canceled the contract, the lease, because it was month to month. There's no reason for him to keep paying the rent. And let's say he didn't want to run the business anymore. Let's say he was not getting money from Mike. And if he thought Mike was running the business, well, he spent all that money on computers. Even if whether you take his number of 300,000 or Mike's number of 50,000, that is still tied up in computers that he could have gone, taken, sold, and tried to recoup his investment to mitigate his damages. To say, hey, I own these computers. This business is closed because of COVID. I'm going to take these back. He did not do that. Again, that adds to the scale. The fact is, I think we can all assume the reason he never grabbed Denny and drove up to North Carolina is because those games were running and they were making money. We have, from Mr. Park's testimony, he drove by. There were people in the store, there were cars in the parking lot. The business was operating after COVID had ended. So now we have Mike Park, Cheney Madden, Artie Lupton, and Sean Lee all providing evidence that supports the fact that Mr. Lee was operating the business, was collecting the profits, was ducking phone calls, and was keeping the money. There's no other way to say it. So let's go through the PowerPoint. During my opening my opening statement, sorry, I promised you that I was going to deliver information based on this PowerPoint. So we're gonna go real quickly through here and see what I delivered, what I not. There we go. Thank you. All right, let's go to the first one. First of all, I've got testimony from Mike Park defining what a skill gaming center is. We talked about the fact that this particular location was a standalone building, that it was a retail dedicated amusement center that featured legal games of skill. Now, legal is the term, Mr. Lee, when he was on the witness stand, kept saying it's illegal. No, it was legal until it wasn't. It was legal in that particular county, and it goes on a county by county basis based on the testimony. So it was legal in 2019 when it started, and then the county decided to stop. Then it was not illegal. It was no longer a permitted activity in the county. That may be a fine distinction, but that's essentially the legal definition of what happened. The county said, no, we don't want this business anymore. And so while they had them as legal in 2019 and 2022, the county exercised their right to stop. Now, let's go on to the next slide. We also introduced you to the two individuals and their skill set. I think the evidence has been very clear. Mike Park, as the operator, has extensive experience in gaming, games of skill, and continues to operate in that. Mr. Lee, I think it was also very clear from his testimony, he is a sophisticated investor, very savvy investor. He runs currently 5 or 6 different businesses and investments. I do not believe for 1 minute that Mr. Lee could not find someone to operate this business for him if he chose to do so. I don't necessarily believe that Mr. Lee came up from Georgia to North Carolina to run the business. I think the evidence is clear that he could have hired someone to run the business, someone who would be cheaper than a 60% partner, and then decided to cut Mr. Park out of it. That's probably the most likely scenario. And so you were introduced to the individuals, and you heard testimony from both of them about what they brought to the partnership. Go ahead. Next, we talked about the timeline of events. The fact that their partnership began in the summer of 2019. Mr. Lee signed the lease in September 1 of 2019. Mr. Park testified about what happened between September 1 and December 30th, or near the end of the month. That's when they got permitting done. That's when they got the build out completed. And December 16th, 2019 is important because that's the day that Mr. Lee got that $50,000 he needed to complete the work. That's the day he sold 10% of the company to Ms. Madden. And so that's the day that really triggers the ability to open the business. And by the end of 2019, the build out was complete and the store was open. Seemed like they were ready to go. They're going to do fantastic business until COVID stops the whole train in March 2020. And at that time, the store shut down. The store reopened in September of 2020. My client says Sean Lee took over the operations. Sean Lee says he did not. All we know is someone ran it. And if it wasn't Mike Park, it had to be Sean Lee. There's no other option. Then in November of 2022, the store closed for good. And so we know that it is at that point in time the store ended. And so the profits that were made between September of 2020 and November 2022, that's the 27 months that we're talking about. We'll go into the next one. So Sean Lee, when he operated the business, the evidence showed he presented no accounting records, financial statements, or other reports. I would say he admitted that because he says he didn't operate the business. So it would flow that that's in, if he's not operating the business, then he's not sending the report. Mr. Lee also gave no details of operations. Again, Mr. Lee says, I didn't run the business. It wasn't me. It wasn't my job. Except he waited till today to tell us that. He could have told us that when Mike Park called 100 times and Jamie Madden called 100 times and Artie Lupton called 100 times. Mr. Lee never said that until this week. And of course, there are no profit distributions. Except maybe to Mr. Lee himself, he may have had profit distributions. Okay, let's go ahead and move on. So we presented evidence to you about the three kinds of agreements, the verbal agreements, which is between Mr. Park and Mr. Lee. Mr. Park is the operator and Lee is the silent partner. We talked about the investment agreement, which is from Ms. Madden. He presented the copy of that agreement into evidence. And then we talked about the lease agreement, which is the lease with Blackman that Ms. Lupton was. Okay, so that final partnership structure was 50% Mike Park, 40% Sean Lee, 10% Jamie Madden. And Ms. Madden's 10% came over to Mike Park, so he had 60%. Sean Lee had 40%. Also, this is unrefuted. So we have three causes of action. As Mr. Begg mentioned, we have decided that we are not going forward with the conversion claim. So we're going to talk about breach of contract. We have the breach of contract that stems from the failure of Mr. Lee to pay the profit distributions, to send the financial reports. Mr. Park is entitled to all of those financial reports and all of that distribution that should have gone to Ms. Madden. So he has the right to claim not only breach of contract for himself, but also breach of contract for Ms. Madden. We also have breach of fiduciary duty. I took Mr. Park through each of the elements of the breach of fiduciary duty cause of action as outlined in Georgia. He discussed each one with you during his time on the witness stand. And the Judge McAfee, is going to go through what that law is and what those elements are. But I can tell you, I had the law in front of me and I made sure Mr. Park addressed every single element so that you can go back into the jury room and confidently say, yes, Mr. Park showed this, yes, Mr. Park showed that, and go down the list. What happened next? There's really no refuting what Mr. Park testified to. And then the third one is for fraud and misrepresentation. Likewise, we have the misrepresentation. What is that misrepresentation? That is a phone call where Mr. Lee said, I want to take over the operations. When you say you're going to take over the operations, that means you have a lot of responsibilities you are assuming. That is the representation. Part of those responsibilities are you got to make payments to your partners. Now, that, of course, is the key to breach of fiduciary duty, breach of contract, and the fraud, is that you have to make those payments. That is what you're committed to do. The misrepresentation was the statement by Mr. Lee, I'm going to take over, I want to take over operations. Once he said that, the evidence has now come to show that he knew all along he was never going to pay his partners. He knew that was his intention, was he was going to take over the operations, he was going to take over the business. And he was going to lock out Mr. Park, he was going to lock out Ms. Madden, and he was going to lock out Ms. Lupton. And that's why he never answered their phone calls. He didn't want to have to go to them and either make up a story as to why he wasn't paying them, and he didn't want to go to them and say, I just decided to keep the business for myself. He made that decision, regardless of which reason he chose not to answer the phone. He didn't, and as a result, all three of those individuals who told the same story in this trial, all three of those individuals did not get the money that they were entitled to get. Finally, I want to talk to you about damages. So, in this case, we've tried through discovery to get a better handle on the finances of the company. We asked Mr. Lee for bank statements for the company bank accounts. Never got it. We asked Mr. Lee for financial records. We never got it. We asked Mr. Lee to provide us any profit and loss statements that he has for the business. Never got them. We don't know at all what profits that game store made from those 27 months, from the time it opened in September until it closed in November of 2022. We don't know. What we do know, however, is what Mr. Park was able to do. We do know that Mike Park in month one made $36,000 in net profit. And he made in month two, $53,000 in net profit. We know that in a 2-month period, he grew the business by 50%. And we know that the average of those 2 months is $44,738. We know that Mr. Park was entitled to 60% of that. And that 60% would be $26,843. We know that there's 27 months of operation that business operated. We know for a fact that business opened in September or reopened in September of 2020. And we know for a fact it closed in November of 2022. So we know the dates. We know an estimate. Mr. Park testified, however, that business could have made far more than $53,000 a month. The $53,000 a month was only in month two. That with this plan to grow the business, the target market, the demographics, county, that was an opportunity for him to really tremendously have a tremendously profitable business. So therefore, we're asking you, the jury, to award Mike Park $724,755.60. We're also asking you to award Mike the $50,000 that Ms. Madden invested. Why? Well, Mr. Begg made the point saying he's not entitled to it. He's not entitled to it. Yes, he is, because that $50,000 was an investment for a 12-year business, not a 2-month business. And that because it was a 12-year business investment and she only got 2 months of actual profits, even if you grant us the relief we're seeking of 27 months, it is still nowhere near 12 years, which is what Ms. Madden thought she was investing in. So therefore, we're asking for a total amount due of $774,755.60. Now, when I started this case in my opening, I also talked to you about attorney's fees. We don't need to talk about the dollar amount of attorney's fees. What I do need you to do is check that box. So when you go back to the jury room, you're going to get a jury form. And I'm going to show you on the screen what that is going to look like. You may not be surprised to know that we would like for you to check the box next to the word plaintiff. And so to help illustrate what we're asking you to do, we're asking you to put a big X next to the "we, the jury, find in favor of the plaintiff." And then under section 1A, we are asking you to insert that number, the $774,755.60, as actual damages. And so that section 1 is for breach of contract. Scroll down. You'll get to number 2, which is breach of fiduciary duty. We, the jury, find in favor of the plaintiff. Please put an X there and write the actual dollar amount there. And then number 3 is for fraud. Same thing. We ask you to find in favor of the plaintiff and insert that dollar amount. Just to be clear, the law says we're only allowed to collect an element of damages once. So even though you're putting that same dollar amount in each time, we don't get 3 times the 774. It's the 774, 755.60. That's what we're seeking under all of these different causes of action. All right, scroll down. And then for this line, this is the one about attorney's fees. As to whether the defendant has acted in bad faith, has been stubbornly litigious, and is entitled to attorney's fees and expenses of litigation, we ask you to say, we, the jury, find in favor of the plaintiff. That's all you have to do about attorney's fees. Next comes a much easier job. When it comes to the defendant's claims, all we're asking you to do is say no. The defendant, we, the jury, find in favor of the plaintiff. The defendant is not entitled to damages, is not entitled to attorney's fees, and is not entitled to punitive damages. And so that is one thing Mr. Begg and I agree. I think you should all say no to the defendant's counterclaims. And I appreciate his candor in that discussion. Is there anything down below there? Oh, okay. So this is the attorney's fee section. We ask that you say no to the attorney's fees. So at this point, I want to thank you for your attention. I want to thank you for taking notes and being vigilant. Thank you for giving up your time. I know I've never met a juror who said, I really want to be in jury duty today. And so I know it's a sacrifice for y'all, and I'm very thankful for this opportunity to present Mike Park's case to you and to give you an opportunity to do what the scales indicate. All of the scales, we're taking in the football analogy, which I think is excellent. I'm going to use that by the way. The football analogy, if that's your preference too, I think Mr. Park has taken it to the 50, beyond the 50-yard line. And so we ask that you come back with a judgment for Mike Park for $744,755.60. Thank you.
All right, members of the jury, it's now my duty to charge you on the law that applies to this case. That process takes about 15 to 20 minutes. Does anyone need a break before we dive in? All right, you'll also receive a copy of these instructions during your deliberations. So, you are considering the case of Hyman Mike Park as plaintiff versus Sean Lee as defendant. Plaintiff filed this action here in the Superior Court of Fulton County, in which he brings claims for 1, breach of contract, 2, breach of fiduciary duty, and 3, fraud. The plaintiff's claims for conversion have been removed from your consideration. You should draw no inferences for or against a party as a result of this removal. Defendant brings counterclaims against Hyman Park for fraud. The party bringing any claim must prove every essential element of its claims by a preponderance of the evidence. This is sometimes called the burden of proof or the burden of persuasion. A preponderance of the evidence simply means an amount of evidence that is enough to persuade you that the party's claim is more likely true than not true. If the proof fails to establish any essential part of a claim by the preponderance of the evidence, you must find against the party making that claim. When more than one claim is involved, you should consider each claim separately. In deciding whether any fact has been proved by a preponderance of the evidence, you may consider the testimony of all the witnesses, regardless of who may have called them, and all the exhibits received in evidence, regardless of who may have produced them. If the proof fails to establish any essential part of a party's claims by a preponderance of the evidence, you must find for the opposing party as to that claim. The defendant has filed what are known as counterclaims. That is, the defendant claims that the plaintiff owes him instead of the defendant owing the plaintiff. A counterclaim is covered by the same rules of law that govern the plaintiff's claims. The defendant must prove his case by a preponderance of the evidence. Evidence is the means by which any fact that is put in question is established or disproved. Evidence includes all of the testimony of the witnesses, as well as the exhibits admitted during the trial. It also includes any stipulations, which are facts agreed to by the attorneys. Evidence may be either direct or circumstantial, or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing the fact. Circumstantial evidence is proof of facts and/or circumstances that tend to prove or disprove another fact by inference. That is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You, the jury, must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witnesses' manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The credibility of a witness may be attacked by disproving the facts to which the witness testified. A contract is an agreement between two or more parties for the doing or not doing of some specified thing. To constitute a lawful contract, there must be parties able to contract, a consideration for the contract, the agreement of the parties to the terms of the contract, and a lawful subject matter. A consideration is valid if any person who promised is entitled to a benefit, or any harm is done to one who receives the promise. The consent of the parties is essential to the validity or enforcement of a contract, and until both parties have agreed to all its terms, there is no contract. Until the contract is agreed to, a party may withdraw an offer or bid or proposition. An enforceable contract does not exist unless the parties have reached agreement as to all material terms and conditions, and nothing is left to future negotiations. If there is any essential term upon which agreement is lacking, no meeting of the minds exists, and a valid binding contract has not been formed. An enforceable contract does not exist if its terms are incomplete, vague, indefinite, or uncertain. Any particular contract provision, essential or material to the parties, can be an essential term of the contract. As a general rule, there is implied in every contract for work or services a duty to perform it skillfully and carefully. The law requires persons undertaking to perform services requiring skill the duty to use that reasonable degree of skill, and ability that would be used under similar conditions and circumstances by others of the same business or profession. A contract may be modified by mutual consent of the parties, which need not be expressed in words, in writing, or signed. But the parties must manifest an intent to modify the original contract, and the modification must be supported by at least slight consideration. Whether there is, in fact, a modification is a question for you to decide. Damages on a claim for breach of contract are given as compensation for injuries sustained. Damages recoverable for a breach of contract are such as arise naturally and according to the usual course of things from the breach, and such as the parties contemplated when the contract was made as the probable result of the breach. Remote or consequential damages are not allowed whenever they cannot be traced solely to the breach of the contract, or unless they may be computed exactly, such as the profits that are the immediate fruit of the contract and are independent of any collateral enterprises entered into in contemplation of the contract. On a breach of contract claim, the burden of proof is on the plaintiff to show both the breach and the damage with sufficient evidence to enable a jury to calculate the amount of damages with a reasonable degree of certainty. A failure to prove damages is fatal to a claim. In every case of breach of contract, the party not breaching it has a right to damages. But if there has been no actual damage, the party bringing the claim can recover nominal damages that will carry expenses of litigation. Nominal damages are a trivial sum, important for the fact of the award, but not meaningful in amount. The expenses of litigation are generally not allowed as a part of the damages, but if a party has acted in bad faith, or has been stubbornly litigious, or has caused the party bringing the claim unnecessary trouble and expense, you may allow them. Bad faith arises out of the transaction upon which the complaint is based and refers to a time period prior to when the lawsuit was filed. Bad faith is not simply bad judgment or negligence, but it imports a dishonest purpose or some moral obliquity, and implies conscious doing of wrong, and means breach of a known duty through some motive of interest or ill will. Stubborn litigiousness and causing the opposing party unnecessary trouble and expense refer to forcing a party to file a lawsuit when there is no bona fide controversy. If there is a bona fide controversy between the parties, expenses of litigation should not be awarded unless you find the party against whom the fees are to be awarded acted in bad faith. Any necessary expense is that one of two contracting parties incur in complying with the contract may be recovered as damages. The plaintiff has brought a claim for breach of fiduciary duty, which is classified as a tort. A breach of contract does not always give rise to an action for a tort, but such an action will lie if, in addition to breaching a contractual obligation, it also violates a duty owed independent of the contract to avoid harming the claimant. As for breach of fiduciary duty, the plaintiff must show 1, the existence of a fiduciary duty, 2, breach of that duty, and 3, damage proximately caused by the breach. To satisfy the first element of this claim, the plaintiff must prove the existence of a partnership. The parties agree, in this case, that a partnership existed. Fiduciary duties and obligations are owed by those in confidential relationships, i.e. relationships where one party is so situated as to exercise a controlling influence over the will, conduct, and interests of another, or where, from a similar relationship of mutual confidence, the law requires the utmost good faith, such as the relationship between partners, principal and agent, etc. A person commits the tort of fraud when that person makes a misrepresentation that is intended to deceive and that does deceive. Fraud may not be presumed, but slight circumstances may be enough to prove its existence. To prove fraud, the following elements are required. 1, a false representation. 2, intent to deceive. 3, an intention to induce the claimant to act or refrain from acting in reliance on the false representation. 4, justifiable reliance by the claimant on the false representation. And 5, damage to the claimant. If there is a willful misrepresentation of a material fact, which is made to induce another person to act and causes that person to act and the person is injured, then the person who is injured has a right of action. In all cases of deceit, knowledge of the falsehood constitutes an essential element. A promise made without a present intent to perform is a misrepresentation of a material fact and is sufficient to support a cause of action for fraud. A fact is material if it would be likely to affect a reasonable person's decision regarding the transaction at issue. Promises as to future events generally cannot constitute fraud unless they are made with a present intent not to perform, or where the promiser knows that the future event will not take place. Present intent not to perform may be proven by direct evidence or by circumstantial evidence, but it must be proven. It is not presumed from non-performance alone. Reliance is justifiable if under all the circumstances the claimant was reasonable in relying on the representation. If you find that the claimant did not rely on the representation, or that any reliance was not justifiable under the circumstances, then you must find against the claimant. Damages on a tort claim are given as compensation for injury done. When one party is required to pay damages to another, the law seeks to ensure that the damages awarded are fair to both parties. If you believe from a preponderance of the evidence that the claimant is entitled to recover, you should award to the plaintiff or defendant such sums as you believe are reasonable and just in this case. As to the claim for breach of fiduciary duty, if the injury is small or mitigating circumstances are strong, only nominal damages are given. Nominal damages, again, are a trivial sum important for the fact of the award, but not meaningful in amount. In tort actions, there may be aggravating circumstances that may warrant the awarding or imposing of additional damages, called punitive damages. Before you may award punitive damages, the claimant must prove that the other party's actions showed willful misconduct, malice, fraud, wantonness, oppression, or that entire want of care that would raise the presumption of conscious indifference to the consequences. The claimant must prove that the other party is liable for punitive damages by a higher standard than that for proof of other damages. That is, by clear and convincing evidence. Clear and convincing evidence is defined as evidence that will cause the jury to firmly believe each essential element of the claim to a higher degree of probability. Proof by clear and convincing evidence requires a level of proof greater than a preponderance of the evidence. If the party bringing the claim fails to prove by clear and convincing evidence that the other party was guilty of willful misconduct, malice, fraud, wantonness, oppression, or entire want of care that would raise the presumption of conscious indifference to the consequences, then you would not be authorized to award punitive damages. Mere negligence, although amounting to gross negligence, will not alone authorize an award of punitive damages. Punitive damages, when authorized, are awarded not as compensation to a claimant, but solely to penalize, punish, or deter. I want to emphasize that anything I did or said during the trial of this case was not intended to and did not intimate, hint, or suggest to you which of the parties should prevail. Whichever the entitled is entitled to a verdict is a matter entirely for you to determine, and whatever your verdict, it must be agreed upon by all of you. My interest in the matter is that the case be fairly presented according to the law, and that you, as honest, conscientious, impartial jurors, consider the case as I have instructed you, and return a verdict that speaks the truth as you find the truth of this case to be. Your verdict should be a true verdict based on your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or another. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic or corporate status, for or against either party. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media to communicate with anyone any information about this case or to conduct any research about this case until I accept your verdict. Your verdict must be unanimous. One of your first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. You should carefully consider all the evidence in the case and deliberate with a view toward reaching a unanimous verdict consistent with your consciences and oaths as jurors. Avoid premature fixed opinions. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should never surrender honest convictions or opinions in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Do not begin your deliberations until I send you the exhibits and the verdict form, which we will do so shortly. Any objections to the charge as given by the plaintiff and by the defense? And do we still have the verdict form? All right, if I could have that. All right, members of the jury, I'll also note for you that in addition to the copy of the charge that I just read, for your, if you should want to refer to it again, we've also prepared a verdict form for you to go through in reaching your decision. It's numbered by count, should be straightforward on how to follow it, what to fill in, and where to sign at the conclusion. The last thing I would note is that our schedule from here, once you retire to the jury room, again, we're on your time. If you would like to formally break for lunch, you can do so. If you do that, remember not to resume your deliberations until all of you are in the same room together again. That being said, though, we were able to order some lunch from Mellow Mushroom, and we're going to have that set up on the tables in the hallway there. I think it should be here and delivered in the next 15, 20 minutes or so. So if you all just want to take advantage of that, you can do so. Again, just decide as a group and let Deputy Scott know what is going on. And with that, I'll ask juror number 30 to stay behind, but the rest of you can now retire to the jury room.
All right, adjourned.
Yeah, it's me.
All right, juror number 30, as you might have guessed from our math, you are alternate. But that doesn't mean you're off the hook just yet. There have actually been plenty of times where I've had to sub in an alternate, depending on how long deliberations go or if something happens in there where we need some backup. But I don't want to keep you here unnecessarily. So if you want to stick around and have the lunch that we provided, feel free to do that. We'd actually ask that you wait in a separate room on the hallway that Deputy Scott can show you. But if you'd rather get back to your life, feel free. But I would say that if you could remain on call and able to get back here within, I know you're ways out, but maybe an hour and a half, 2 hours, depending on traffic. Just if we do get word that we need you back, we're able to reach you. And at the moment that we know that the jury has reached a verdict without you, we'll give you a call to let you know then that you're formally released from your service. But otherwise, go about your life, get back to business, and if we don't see you again, certainly want to express our gratitude for your service this week. Any questions about anything we've covered or where we're going from here?
If you did need me, if I go home, getting back here in an hour and a half is gonna be a stretch.
Okay.
I did MARTA and I drive part of the way, so like that round trip it could be a couple minutes.
I'll put it this way. I think in all likelihood, the only chance if we do need you, it's going to be because we're starting deliberations tomorrow morning. So I would say you're going to know today, and it would be that we're bringing everyone back with you for tomorrow morning. So I don't think you're going to have to go home and then come back today.
Do I need to give bailiff a phone number or something?
We should already have it. Mr. Derryberry,
Okay.
we'd already have that contact information. Keep that phone off silent. And again, we're going to let you know if we need you back tomorrow morning, well before the end of the day. So thank you, sir. Take care. Council, do we have that stack of the exhibits 1 through 13 in the binder?
Yes, let me just put the.
I don't think I inadvertently took anything with me. I think it's all, yeah, it was only those two. Sorry, I pulled it from. So this is
That's all right.
1 and 2.
For the record, I believe this was marked as court's exhibit 1. Is that correct?
The charge was.
The charge was,
The
okay.
charge is, which I have here. And since we don't have the court reporter with us, I think we'll plan to file that
Okay.
on the record along with the verdict form whenever they've got that completed. So with that, we've got this binder of exhibits with just the charge and the verdict form. And I believe that's everything that goes back. And once Deputy Scott hands that to him, they can begin the deliberations. All right, unless there's anything to take up, we'll be off the record.
Phone numbers to Deputy Scott.
If you can give those to Ms. Sue and just be within, 10 minutes thereabouts, if you want to wander throughout the building. And we'll be sending out an email as soon as we get word. I think we also generally, if you just have the live stream pulled up, we have that light. We'll switch the camera view so you can see that light when it comes on. And because there might be some questions early on, so I would ask that, don't go too far. All right, nothing else then, we'll be off the record.
Do that part. It's up to them now.
George,
All right.
I'm right back in. a good thing for us.
I don't know,
Yeah.
Who knows?
because.
Everything, that's it?
For neither.
I think it's probably because that's full, yeah.
They did a good deal where Joe, Lee, Jamie, and Artie all complaining about this. You've done this before.
Yes, I have.
4412335.
Say, I just don't wanna, by accident.
Yeah, got it.
We're gonna be in the conference room across the hall, so. Don't hear from me. Don't bring us in there. You stay on the door. Over there.
How long do you think we'll be over there? I don't think I need my.
Pardon me?
How long do you think we'll be over there?
Yes, ma'am. Right, 542-1915. Very good, thank you.
Do I need to bring my charger?
I think you ought to go ahead and pack up.
Oh, everything, okay.
Yeah. I don't, I think we'll talk a little bit then. It's my expectation that you can head out.
Did you want these chargers back? You want, is that Mike's copy?
I have a copy. And did you want it for?
Sure.
Yeah, I was gonna say, you can put it in your file. Five.
Yeah.
So I thought we'd sit for a little bit then. Yeah, if you
Okay.
want to leave early, you can. Otherwise, we'll grab lunch or something and then
Okay.
I got a feeling nothing's gonna happen right away.
Right.
Amen. Great job.
Yes, same to you. I enjoyed working with you.
Yeah, absolutely.
Look forward to
Nice to
the
meet you.
next one.
Yeah. Hopefully, next one will have some contractual
Yeah, maybe some-
provisions we can rely on.
Yeah,
Something, right?
yeah, a little bit of contract work would be nice, right?
Or just, if you ever, I mean, I don't think you would, but if you need us, we're just in this conference room right here.
Okay, sounds good.
We can actually just probably go out that door to get to the.
Pardon me?
We can probably go out that door to get to our conference room quick. But,
Yeah.
I mean, either way,
Where did Mike go? He went out the other door though, right?
I think so. I think he went to the restroom.
Oh, okay.
Oh, okay.
I'll tell you what, I think it's rare where a jury doesn't have a question. It seems like it's every time.
Man, see, come on.
All right, let me check in, make sure we still got our court reporter over Zoom. Can you hear me, ma'am?
Yes, Your Honor, I'm here.
All right, fantastic. So we are back on the record now. And we have all parties in council present, and was informed by Deputy Scott, jury began deliberating at about 11:10, so it's been about 50 minutes. They just handed me a question, which I will mark and tender as Court's Exhibit 2. And it's a new one for me. It reads, it's a long one. 3B, as to whether the defendant's conduct warrants consideration of punitive damages, dash, we the jury find in favor of the plaintiff. Star, we are confused by the wording of this statement. Dash, we the jury find in favor of the defendant. And then it's signed by the foreperson with another star at the bottom. We need to make sure we check the one that favors the defendant. If anyone wants to read that and review it, it doesn't look good for the plaintiff's claim for punitive damages. My inclination, after soliciting input, would be to bring the jury in and advise them, essentially, that if they wish to find in favor of the defendant on 3B, they should check the box that says, we find in favor of the defendant.
So it's 3B, is that under the plaintiff section or I think it's under the plaintiff's.
It's the plaintiff
fraud
section.
claim.
That's right.
Yeah, I don't think it looks good.
But the form literally says,
Yeah,
unless you, there are phrasing or options, but I'll give them both options. I'll do this. Should you have found that the plaintiff did prove by clear and convincing evidence conduct that warrants punitive damages, you would check this box. Should you find that the plaintiff did not prove it, you would check this box.
okay.
I'll do something like
I
that.
think that's a good way to explain it.
If you could bring in the jury, then. Thank you. Please be seated. Members of the jury, I received your note, and after conferring with counsel, I can offer you these additional instructions. I would first note that these instructions are to be considered as a whole with the other instructions I already gave you, and you should not place any greater emphasis on this versus what you've already been told. With that said, I charge you that as to question 3B on your verdict form, 3B is where you should note your finding on the plaintiff's claim for punitive damages. If you were to conclude that the plaintiff has not proven, or has proven, rather, by clear and convincing evidence, conduct that warrants punitive damages, you would check the box that says, we find in favor of the plaintiff. If you were to find that the plaintiff has not proven by clear and convincing evidence such conduct, you would check the box that says you find in favor of the defendant. With that, I would ask you to resume your deliberations. Thank you. Any objection by the plaintiff?
No, Your Honor.
Any from the defense? We'll be off the record, and I'd say, please again, don't go far. I think they're working through it.
One thing is unrelated to anything we're doing. When I was outside, I ran into that, looked like a mother and son that was looking for some guidance from the court. This court date, we emailed Mrs. Sue about it, so.
Okay.
I'm not sure if they're still out there or not.
Okay. Well, Deputy Scott, maybe you can figure out if it's a criminal or a civil case, and we'll get a name, and we'll figure it out. All right. Thank you.
All right, thank you, Joe. Okay, let's go back to our little break. I think we're gonna. I think this is imminent.
Is it, do you think that's for just that slot?
Hold on, Court. Hold on. Hold on, hold on. Hold my earpiece on. Hey, can you hear me? What's going on? Uh-huh. Okay. Okay, then, let me know, okay. All right, okay. Okay, bye.
Deputy Scott.
Yeah, okay.
All of that. I'm gonna do it. Because every time I do something, down here something trash. We'll see. Yeah. Checking. Oh, I see. Yeah, I do.
Listen, Mr.
Did you find that lady? Did you find that lady and her son that were looking? Okay.
Yeah, I don't know where they went.
They
but
were
they're-
walking up and down the hall when I saw, when we left out of here.
If it came across someone else, they probably got ready.
Okay.
Most likely, I would have told Buster Chamber to talk to the case manager.
Oh, okay.
Uh-huh.
They had court there anyway.
Right.
Whoever it could have been another deputy, saw somebody at work.
Mm-hmm. That's what I told him. I was like,
Kind of go back, get into the same thing.
yeah,
Mhm.
that's good.
They'll come. This court will be closed all day, they'll still come try to knock it out.
Mm.
And be a luck of mine to be in court. Man, see the court come on. Luck around, they'll pop in here and what like this
Mm-hmm.
court.
Yeah,
Yeah.
All good, Madam Court Reporter?
Yes, Your Honor, I am. Thank you.
All right. Then we are now back on the record, and I've been informed that after a little over an hour of deliberations, the jury tells us they have reached a verdict. And so I'll ask Deputy Scott to retrieve the jury. All parties and counsel are present. Oh, shoot. I need to be.
That's the jury. Guilty pleasure, Judge.
Thank you, Deputy Scott. Members of the jury, I've been informed that you have been able to reach a verdict. And so first, if I could ask the foreperson to identify themselves by juror number. And juror number 6, have you reached a verdict? Was it unanimous? Has that verdict form been filled in, signed, and dated by you? Then you can hand that to Deputy Scott so I can inspect the form of the verdict. All right, and now juror number 6. What we do next is we have to publish the verdict by reading it into the record. Our court reporter is actually joining us remotely today. But you can remain seated, and if you could just read that that verdict aloud for us all today.
In the Superior Court of Fulton County, State of Georgia, Mike Park plaintiff versus Sean Lee defendant. As to whether the defendant breached a contract with the plaintiff, we the jury find in favor of the defendant. As to whether the defendant breached a fiduciary duty, we the jury find in favor of the defendant. As to the claim of fraud against the defendant, we the jury find in favor of the defendant. As to whether the defendant's conduct warrants consideration of punitive damages, we the jury find in favor of the defendant. As to the claims of fraud against the plaintiff, we the jury find in favor of the plaintiff. As to whether the plaintiff's conduct warrants consideration of punitive damages, we the jury find in favor of the plaintiff. As to whether the plaintiff acted in bad faith, has been stubbornly litigious, or has caused the defendant unnecessary trouble or expense to warrant reasonable attorney's fees and expenses of litigation, we the jury find in favor of the plaintiff.
All right, if you could hand that back to Deputy Scott, and if counsel would like to inspect the verdict form, I'll make that available here.
Thank you, Judge.
All right, any objections to the form of the verdict on behalf of the plaintiff
Thank you, Your Honor.
and on behalf of the defendant? Is anything else required of this jury on behalf of the plaintiff?
No, sir. No, Your Honor.
Anything further on behalf of the defense? Members of the jury, that concludes your service with us this week. If anyone wants to speak with you now, it's purely up to you and your decision. A lot of times I know that the attorneys want to get some feedback, hear what went into your deliberations. And so I'm going to go back and thank you personally. And then I'll ask if anyone wants to stick behind. I offer the attorneys a chance to come back and speak with you as well. But you can go ahead and run and get on out of here if you'd like to go back to your normal lives. Let me just say again, thank you so much for the time, your patience, your deliberations throughout the course of this week. If anyone still needs work excuses, feel free to let us know. But otherwise, it's with the thanks of this court that you are excused. Thank you. All right, counsel, I will plan to file the verdict form and I will provide the court's exhibit 1 and 2, which would be the charge and the jury note to the court reporter. I would instruct Mr. Collins, if you can provide the email of the court reporter who is with us here, and you can give that to Ms. Sue so we know who to send that to. Otherwise, my plan would be to file the final judgment affirming this verdict by the end of the week. And so unless there's anything else for the record, we would adjourn this matter. Is there anything else on behalf of the plaintiff?
Yes, sir.
Anything on behalf of the defendant? All right. Thank you both. We are adjourned.
Thank you, Your Honor.
Yes, thank you, Madam Court Reporter.
You're very welcome.
Judge, I do like to talk to jury members if there are any who are willing to chat with me.
Absolutely. Stick around.
Thank you.
Mr. Begg, did you want to do that as well?
I would like to.
So what we're gonna do next is, if jury members are willing to talk to me, I'm gonna go back there and talk to them, try to get a sense of how they reach their opinion, things that they found persuasive
Yeah. Thank you.
back in the conference room, and go through why I think the jury ruled the way they did.
They come back in here though, right?
Now, they have their own door.
Really? We came back in the courtroom and I was questioned.
Yeah, this is a weird, I think it's because this courtroom is on the end.
Uh-huh,
They have like their own door.
where they can leave, but
Right.
that's if they don't want to be questioned, right?
Right. So I don't know if we're gonna go back to them or,
I thought he said they're coming back.
okay, because the last time I talked to the jurors, they were actually they're in the jury.
They were in their room and y'all went back to the jury
Yeah,
room?
two attorneys went back. Yeah.
Okay. Let me see. Let me copy and paste this. I'll just put this in that same chain that we, with everybody on it.
Excuse me, attorneys, just to double check, I wanted to make sure this is a takedown only.
So far, yes.
Okay, all right, very good. That's all I had. Thank you.
All right.
Enjoy the rest of
Thank
your day.
Thank you, ma'am.
You're welcome. Bye-bye.
Copy this court reporter. I don't know if should I copy the court reporter on this email to Elizabeth Sue?
Yeah, that's a good idea. That way she can get reply all.
Right.
If needed. I don't think she's gonna need her, but because this was one of three. If they
Mhm,
want a transcript, they're gonna have to call Veritex, not her.
right.
So they're gonna come back in? Or,
I don't know. I mean, that's why we're just saying, I don't know if they're going to ask us to go back there or if we're going to
I
stay
think the
here.
judge, I could have sworn I heard him say he was gonna go back, thank them for, their service and then bring whoever wanted to come back.
So I bet
back
he's
here.
asking his own questions.
Right.
You know, what can I do as a judge to make your experience better? Kind of
Yeah.
Stuff. Just like, I want to know what key things they thought were important,
Of course.
what was not important, you know. What moved them,
Mm-hmm.
that way I can come back and
What didn't?
learn from things that I did wrong or could do different. And give Mike give you feedback on what you need to do from a business standpoint. So you don't have to do this again. Right.
can I appeal this?
Mhm. Talk about that in.
I'm glad the court reporter worked out.
Yes,
I was very happy about that.
we needed her.
Yeah. No, why it's so hard to find reporters? She said yesterday the schools, like their schools stopped. They don't
Say
have
what
court
now?
reporter schools. Yesterday she was
Yeah.
explaining something as to why there's like a drought. Oh, and she also said like they don't like to do court cases. They like to do just
come in.
depots.
Yeah,
Do a one and done.
the biggest was Brown.
Attorneys, y'all wanna come back?
Oh, okay.
Yes, thank you.
Oh, just attorneys,
Yeah,
right?
you
We
said-
say, okay, all right. Thank.
Oh, she came?
Oh, I
So
can,
she had called
okay,
in.
all right. Copy that.
Clients can't come, so you stay there.
Okay.
Huh?
I was actually very curious because it seemed like.
Well, we'll talk in a minute.
Okay.
All right, we're gonna go to our little public drink. Okay.
They're gone.